I think we're going to go ahead and get started. Our next panel is entitled Is Chevron Retreating? I just wanted to briefly introduce Amy Wildermuth, our moderator, who is the professor at the S.J. Quinney College of Law at the University of Utah. She is an expert in administrative law and environmental law, and she has written a number of articles on Seminole Rock and our Deference, and is really an expert in this area. With that, I'll turn it over to Amy. Thank you.
All right. Well, thank you all, and thank you, Naomi, and the great team here at George Mason. It is always a pleasure to be part of an event here. And so I don't want to say too much in terms of our introductions because I think we might have many questions. This is probably going to be a hot topic. So following up on the last panel in terms of sort of where we are in understanding the historic origins for deference and Chevron deference in particular, this panel is going to explore where we are today in terms of Chevron. And so we're going to go a little out of order from the seating arrangement that we have here, but I'm going to ask Dean Cass to kick us off. So, Ron?
Thank you, Amy. I'm going to start by trying a different joke than Jack Bierman. You'll see this is a completely true story. I was in Northwest DC a few days ago, and I saw a fellow walking around, and behind him, in just single file, were about 12 ducks following him the way they would follow a mother duck. And I wasn't sure he understood that he was being followed. I asked him if he knew he had a bunch of ducks following him around. He said he knew that, but he couldn't figure out what to do about it. So I said, well, why don't you go to the zoo? And he said, it's a great idea. About 4 hours later, I'm walking in the same part of town, and I see the same guy still being followed by the ducks. And I said to him, I guess you didn't like my suggestion. He said, no, it was a great suggestion. We did go to the zoo. Now we're going to go to the movies. So Chevron, we'll tie it in. Chevron, my other analogy for Chevron, other than that sometimes people don't really understand what's being said, Chevron is sort of the legal equivalent of Iraq. Everybody talks about it. Nobody knows what to do about it. And it really isn't so much a thing as a group of things that don't really fit well together. And the more you look at it, the more you realize that it isn't one single entity. Chevron, as the prior panel made clear, right from its inception, was actually a group of different things. And I want to separate out three of them because I think that has a lot of implication for what has happened and what is happening with Chevron. First, Chevron could have been, and in part was, simply new language for trying to articulate the way courts had for 50 years dealt with review of agency decisions. The court says what the law is, the agency implements it, and the court reviews what the agency does for some version of reasonableness. The second thing that Chevron could have been or was is a new rule. It's a rule that equates silence or ambiguity in legislative instructions with an express commitment of discretion to the agencies. Under this version of Chevron, the courts still say what the law is to the extent that there is clear law. But if the law is unclear, then the agency has policy discretion to shape the law. A third version of Chevron, and it's different from the second and meaningfully different, is that it articulated a new rule that gives agencies the discretion to interpret the law. So it's interpretive authority elaborating laws, meaning not simply policy discretion within a broader legal framework. Obviously, the difficulty in trying to distinguish these is the fact that in exercising policy discretion, agencies have to act within the contours of the law. So there isn't an obvious, clear divide between interpretation of law and exercise of policy discretion, but that in theory is what many people who endorsed Chevron early on thought existed and thought Chevron was consistent with. There was a description by Adam White of Justice Scalia's view of Chevron. If you look at it, you see in the very beginning a notion that the law is interpreted by the courts, but the agencies implement the law, and they ought to, if the law isn't very directive, have a fair degree of discretion over the implementation. But when you look at the opinions over time that Justice Scalia wrote, he was one of the least deferential justices on the interpretation of law at the outset. The fact that you have three different versions of Chevron, however, gives people different ways of reacting to it. So you have people like Scalia who looked at this as a new rule, a new canon of statutory construction, but one that was entirely consistent with a division of authority that was very traditional between courts and agencies. You have some justices like Justice Breyer who do look at Chevron as giving a broader interpretive authority to agencies and giving scope for agencies to act that way, which is why Justice Breyer favors a more complicated way of determining when Chevron deference does and doesn't apply. Because if it gives actual interpretive authority, if it's giving something that is shared between courts and agencies, then you need a different and stronger sense of what justifies Chevron deference. Some justices are clearly uneasy as to which version of Chevron they think ought to exist. Chief Justice Roberts very clearly thinks that what Chevron does is to some extent give agencies interpretive deference over the actual interpretation of law, not over the exercise of policy discretion, which is why in decisions like City of Arlington and King, you see a great deal of unease on the Chief Justice's part in saying that an agency is entitled to Chevron deference. But because what he's trying to do is to carve out where an agency does get deference on interpretation, it's very difficult to come up with a rule that's consistent with a commitment to having courts interpret the law. You have the differences in emphasis among the justices play out in different cases depending on how pronounced the concern is in that case for a particular justice in giving the agency the authority over interpreting the law, in having the courts intrude on policy decisions, in allowing Congress to outplace some of its lawmaking authority in a world where the delegation doctrine doesn't have any real bite, and concerns also about agency ability to elide clear statement of what they're doing and to let people be at risk as they deal with the agencies over time. The differences among the justices have led people looking at what the court has done to declare that there are 1, 2, or 3 steps for Chevron, that Chevron really is meaningfully different from the APA or isn't meaningfully different, that Chevron Step 2 is essentially arbitrary, capricious review, or that it's really something different than that there are particular weights to be given to the terms reasonableness and to arbitrariness and capriciousness in ways that are different under Chevron. And over time, I think we have seen what Chevron is begin to fragment in a fairly clear way. The fragmentation takes us back to what was in Chevron at the very beginning. It takes us back to something that talks about giving deference to interpretation, but also says, as Adam underlined in footnote 9 very clearly, that the courts are the ones who say what the law is, and they can use traditional tools of interpretation in doing that. As it has fragmented, it has become clear that many of the members of the court are uncomfortable with where we are on Chevron. And I would not at all be surprised to see parts of Chevron change over the coming time. Now, Professor Sharkey has written a paper that I know she will talk about and some others may talk about, that is an effort really to make Chevron more grounded, to really give it some structure in the way it's applied. There's some structure in interpreting when it is that an agency merits Chevron deference, which agency merits it, how much it merits it, and to bring in the agency record as a way of trying to get review to be more focused and clear. I won't say much about the paper, which is a very good paper. I commend it to everyone to read. I will say that I think it's very difficult, even trying very hard to make Chevron work better, to do this in a way that doesn't expand judicial deference in the end, judicial discretion in the end, because judges who now have several different chevrons to choose among in different cases, if they are trying to look more carefully and in more detail at the agency record, are going to have an even bigger job with, I think, even more degrees of freedom in how they handle it. But I share the concern that Professor Sharkey has in her paper, that we're trying to balance both cabining judicial discretion and cabining agency discretion in ways that are appropriate. The most likely change, I think, that will come about in the Chevron space is with our deference, our Seminole Rock deference. I think that while there was a strong movement, Justice Scalia very clearly signaled in Decker his unhappiness with our. He commented about what a bad decision that was. Those who were close to him rarely avoided explaining to him who wrote the our decision. But very clearly there are other justices as well who are unhappy with giving deference to agencies' interpretation of agency rules, which seems to give an incentive for agencies to be less careful than they ought to be. Clearly, within the agency, you'll have different actors who have different views on that. The political actors may want to bind other actors in the future. The staff at an agency tends to favor broader statements that give agencies broader discretion because they have to defend it over time. In the end, I think where we are on Chevron is a place that is unsustainable. I think that the three chevrons have failed to coalesce into one chevron, and I think that what we will expect to see over time is either an abandonment of the formula or effectively a change in it to be somewhat closer to the language of the APA and to the spirit of the APA in dividing the interpretive role from the policy role. And with that, let me just say once again, I think this will be like talking to the fellow with the ducks. At the end of the day, the agencies will say, thanks, we took your suggestion, we liked it, and now we're moving on to another suggestion of our own. Thank you.
Thank you. All right, I'm going to turn it over to Kathy to now talk about her terrific paper, which is entitled, while she's walking up there, In the Wake of Chevron's Retreat.
Thank you. So thank you to Naomi and to the center here. It's a real privilege to be able to be here to talk about my paper, In the Wake of Chevron's Retreat. I should say that I start by noting that there is, as the previous panel pointed out, a kind of surge of contemporary recent interest in Chevron, and in particular in the idea that in recent decisions, particularly of the U.S. Supreme Court, that they might be evincing some kind of retreat from Chevron. And I'm less interested, although obviously it would be less interesting if this were totally false. I'm less interested in whether there is or isn't a total retreat from Chevron, and much more interested, as my title suggests, in what happens in the wake of some form of Chevron retreat. But the real contribution I hope to make in the paper is to suggest that we have to disaggregate. And in particular, I want to use the King versus Burwell case and Michigan versus EPA cases, which numerous scholars lump together as evidence of the retreat from Chevron. And some scholars provocatively suggest it's a kind of judicial power grab on the part of the court, or it's a rejection, a yearn to return, maybe given some historical separation of powers types concerns that the first panel was talking about. But it's rare, and in some sense, Ron, although I'm not going to talk about, he didn't steal my thunder with ducks. I didn't have a duck joke prepared, but he stole the thunder just by illustrating his approach is rather rare, which is really a disaggregation of Chevron, right? He talked about 3 different Chevron rules, and in a sense, what I want to do in my paper is suggest that there are 2 very different forms of Chevron retreat. So very briefly, King versus Burwell is a kind of form that I call setting Chevron aside. Right? The Chief Justice, in the opinion in that case, dispenses with the entire Chevron framework in under 200 words, basically decides in that case that it raises an issue of enormous policy significance, enormous political and economic significance, and as a result, the Chevron framework will not apply. He adds, and I think significantly adds, that in that instance, he uses the language, this is not a case for the IRS, right? He doubts that the IRS has any relevant policy expertise. And what's interesting to me is whether or not he is just using this as a kind of indicator that Congress would not have impliedly delegated authority to the IRS to have passed the rule that it passed, making the interpretation about the subsidies going to exchanges that were created not by the states, but by the federal government. Whether he's using that just as an indicator of the underlying implied delegation question, or whether he's adding that in effect to the kind of calculus. But whichever way you look at it, it's definitely what academics have called a Chevron step 0 determination, right? There are certain types of issues, major policy questions that will be deflected away from the Chevron apparatus. Now, I think it's highly significant. There are all sorts of ways one could distinguish King versus Burwell as being a one-off case, as truly exceptional, et cetera. But what I'm trying to do in this paper is use it in a sense as illustrative, a kind of conceptual model, one form of Chevron retreat, which would be the expansion of this step 0 type space. And I think it's important because if you link what's going on in King versus Burwell with the Chief Justice's dissent in City of Arlington, which Dean Cass also referenced, in that opinion, not only is there a lot of strident, vociferous angst against the ever-encroaching administrative state looking into every nook and cranny of our existence, our lives, some definite, I would argue, kind of constitutional angst about what's happening with the expansive administrative state. There's also, in that case, which you'll recall was about whether or not an agency should get Chevron deference for quote-unquote jurisdictional questions, right? The majority rejects placing jurisdictional questions within this step 0 space. And secondly, another interesting issue, I think, that comes to light by looking at the City of Arlington dissent up against the majority opinion is the Chief Justice notes how much more common it is that there's not a single regulatory agency involved in these questions, that there have been delegations by Congress to multiple agencies. And it's not a big issue in the case. It's just noted. The Chief Justice notes that this is more the norm than an exception to the norm. But it raises, I think, a really significant legal issue, because there's a doctrine that the D.C. Circuit has become somewhat enamored of that suggests that if there has been delegation to multiple agencies, none of them will get Chevron deference, that the premise here is that there's delegation to a single agency. And one of the things I probe in this paper about two forms of Chevron retreat is that there has to be a lot more attention given to this question about implied delegation to multiple agencies and who's going to make that determination and on what basis. So there's several problems, just to get to the normative punch of my paper. I don't like this form of Chevron retreat. I don't like the idea that there could be an expansive, increasing space for step zero type determinations. And part of the reason, again, Ron alluded to this in his talk, is I worry that it opens up an enormous amount of judicial discretion, policymaking discretion, to determine what is an issue of economic and political significance. But secondly, and less often noted by other scholars, think about what happens in King versus Burwell, where the Chief Justice determines that the IRS is not the right entity, has no relevant policy experience in setting up health insurance systems. Well, there's another alternative agency in the case, which is HHS, the Department of Health and Human Services, and it would be much more difficult for the Chief Justice to say that that agency doesn't have the relevant policy experience. And there's an alternative view. Actually, Judge Edwards, in dissent in the Halbig case, which was raising the same issues that were at issue in the King case. It was one of the underlying cases, just from the D.C. Circuit instead of the Fourth Circuit, which is where the King case came from. In a dissent in that case, he argues actually that Congress did give joint delegation to IRS and HHS, and therefore it would have been appropriate to give deference to the agency view there. Now, some of my research has suggested if you go, it's actually a really difficult question to answer, and if you go and look in the administrative record as to what happened, there's some back and forth where it appears the IRS realized that this issue was ambiguous, or if not ambiguous, a very big problem for them in the statute, and reached out to HHS. HHS, in the course of its rulemaking, had made some determinations, et cetera. And the main point of my paper isn't really to suggest whether this was appropriately delegated to both agencies, et cetera, but as a matter of legal determination, it required a lot more of an inquiry than the majority or the Chief Justice gives in the King case, and is a really important kind of issue that needs to be sorted out. Okay, the second type of Chevron retreat, which I'm going to normatively embrace, and again, you'll note that when I say I'm going to normatively embrace, I'm not normatively rejecting King versus Burwell, the outcome in that case, nor am I going to normatively necessarily embrace the outcome in this second case. I'm talking about conceptually how they're framing a form of Chevron retreat, is the Michigan versus EPA case. And I characterize this type of retreat from Chevron not as setting Chevron aside, not as an indirect way to try to move away from a Chevron framework, but as a kind of making room, I call it, for State Farm arbitrary and capricious review. And what I mean by that, again, Ron alluded to this, scholars and courts are all over the map about whether Chevron has Chevron step 0, and then there's step 1, where you do your usual tools of statutory interpretation, and if Congress has been clear, then it's over, versus step 2, which is, has what the agency done been a reasonable construction at step 2? Is that the same thing as arbitrary and capricious State Farm review, or is there in fact a further step 3, which is really State Farm arbitrary and capricious review. So in Michigan versus EPA, what's interesting to me, there's been a lot of attention on that case. Cass Sunstein famously said, "Welcome to the cost-benefit state," after Michigan versus EPA, because it is somewhat astounding that all justices, whether in the majority or the dissent, embrace the proposition that, of course, the EPA would have to consider the costs before regulating. This is hazardous, one of the hazardous pollutants. There's a lot of attention as to whether that's good or bad. Is cost-benefit analysis really a surreptitious mode of deregulation? Should it be embraced instead as leading to more rational, effective regulations and the like? What I want to focus on here, and again, I don't think it's gotten very much attention, is in Michigan versus EPA, in the course of conceiving of this as a Chevron case, namely statutory interpretation about what is meant by appropriate, which the EPA was to determine whether or not it was appropriate to engage in threshold regulation, the majority cites State Farm numerous times in that case. And I want to argue that it sets forward a conceptual model that's a positive one. I want to normatively embrace this, that suggests that what we need is a kind of harder look review, State Farm review, of certain types of agency determinations like cost-benefit analysis, but cost-benefit analysis doesn't stand alone. In fact, I've argued in some previous work that this should likewise apply when agencies are engaged in preemptive rulemaking. It's a separate topic, but I'm going to put it out there because this type of hard look review of what is in the agency record and what they have to substantiate their policy determination need not work always in one direction as a kind of one-way ratchet that means it's going to be harder for them to regulate, so it has a deregulatory thrust. It can work in either direction. There can be a kind of symmetry, but it does mean that there will be judicial review and a kind of more stringent review of that type of policy-based determination that is influencing the statutory interpretation question. And so again, what I want to argue in this paper is that these are two very different forms of Chevron retreat. I'm much more suspicious and skeptical of the expansion of Chevron Step 0, but I would embrace a form of retreat that instead is a kind of retreat, so to speak, of Chevron that just makes room for this elevation of State Farm arbitrary and capricious review. Now, why does this all matter? I think it matters because in the wake of Chevron's retreat, they lead to very different endpoints. So in the wake of a Chevron retreat that would be a massive expansion of Step 0 removes the agency altogether, and I think is not a very helpful way to go about thinking about the resolution of various regulatory problems in society. By contrast, this kind of retreat that allows for the reemergence of a more emphatic State Farm type review, I think will lead to very positive responses by the underlying regulatory agencies. So in other words, I think it will be information forcing on the part of the agencies who will have to have a robust regulatory record to defend what it is that they're proposing to do. And I think that it will also have a kind of quality forcing function, right? That at the end of the day, the types of regulations that they produce will be better. The last thing that I'll say is, looked at in this light, Michigan versus EPA is sort of the second of a 1-2 punch. The first punch coming from the DC Circuit in the Business Roundtable versus SEC decision, which I have argued before, likewise asked for a more stringent, quote unquote, harder look. I wrote a paper called State Farm with Teeth. Many people don't like that kind of imagery, but the idea is you don't want a toothless version of arbitrary and capricious review, something more stringent. And I think I think I can make the case that in the wake of Business Roundtable, the SEC, which was the agency that was the target of that, they overturned the SEC's proxy access rule in that case, responded by hiring more economists, by buttressing the type of cost-benefit analysis they were doing on their regulations, et cetera. So that's the kind of agency response that I think can be a very positive one. And in my view, Michigan versus EPA extends that. Now, I said that would be the last point. The final thing I want to say, and I feel somewhat sheepish because at the point of the roundtable in March, I suggested that the next step, and it's true, it is the next step. It's just I've only taken a baby partial step along what I promised I was going to be doing, which is I'm undertaking a pretty extensive review, starting with the DC Circuit, to look at what I'm calling this State Farm Chevron overlap. How has the DC Circuit, let's say in the last 4 or 5 years, depending on how ambitious I want to be, how have they been understanding the types of issues where Chevron statutory analysis and State Farm arbitrary and capricious review overlap, come together, et cetera? And can one argue that that Michigan versus EPA is embracing a form of a conceptual model that might reorient the doctrine in that direction. So that's where I'm hoping to go, because I don't think we should put too much weight on U.S. Supreme Court cases. I want to put these up, as I said, as illustrative of this conceptual model, and then I hope to test how this model might actually affect doctrine, and importantly, with an emphasis on how agencies are going to respond to such a conceptual model. Thank you.
Thank you, Kathy. All right, so we're going to turn it over to Chris.
Thank you very much, Amy. Well, I feel like I have been placed in a joke, in that old rabbi joke, and so I'm going to say I agree with everything that Dean Cass said, and I agree with everything that Professor Sharkey said. And if you tell me that's impossible, I agree with you too. I want to offer a slightly different framework for thinking about these issues of judicial deference that scholars and judges have been struggling with lo these many years. I think that the struggles are a matter of courts coming to grips with the Big Bang of the 1970s, the regulatory revolution, which is still in progress. Two things happened in that decade. First, we'd had a lot of regulation in the past, in the New Deal and the Progressive Era, but it was largely utility regulation of one form or another, of communications, transportation, electric power, industries, where regulation consisted essentially of regimenting production, of cartelizing producers, and it was conducted almost entirely through adjudication. A big issue would be whether somebody got his television station renewed, or whether an airline got to add a new city route. It wasn't of interest to that many people. It was kind of an insider's game. That was displaced in the 1970s with a new regime of regulation. Agencies concerned with environmental, health, safety, consumer protection, personal finance regulation. It was during these years that the 1960s civil rights agencies moved from beyond policing racial discrimination to policing other forms, beginning with sex. Age would come later, others would come later, and moving toward affirmative action programs to promote the integration of these groups. The new form of regulation was not about production. It was about consumption, and it was about aspiration, more broadly human welfare, dignity, identity, participation, issues of great interest to very large numbers of citizens that would not have cared much about whether one person or another got a new radio license. Second, these agencies used rulemaking. 553 had been essentially dormant in the Administrative Procedure Act for 25 years. The new agencies dusted it off. They were given new mandates under hybrid procedures, such as in the OSHA Act. And they were using what had seemed like a fairly modest, simple procedure to make laws of enormous consequence, often great controversy, often huge costs, hundreds of millions of dollars of costs, presumably commensurate benefits. There was this massive new reality of this new policy-making apparatus establishment in Washington doing things of very great salience under statutes that had passed by massive bipartisan majorities, and they were making decisions that were popped into the hands of the courts. I believe that cases such as those described by others, preeminently Chevron and State Farm, can be best understood as the courts having done two big things with the Administrative Procedure Act in response to this new reality. They simply dispensed with two important aspects of that law. The first was that the 553 decision had to be accompanied by a concise general statement of its basis and purposes. That may have been okay for older regulation, but for the kinds of issues that the court was seeing, for example, in the benzene case, enormously complex cases, huge amounts of scientific public health data, huge conflicts, incommensurate kinds of data. Agencies coming in saying, well, we have expertise and we think it ought to be 10 parts per million. That's not enough, the court said. You've got to explain to us what you're doing. You've got to tell us much, much more. And they began this process of requiring elaborate degrees of rationalization to accompany decisions. Secondly, if the agency does explain itself, and it can convince the court that it is earnestly, conscientiously pursuing the mission that Congress gave to it, that boilerplate stuff in the first paragraph of a statute, the courts were highly inclined to defer because in many cases, such as beginning with Chevron, they didn't really feel that they had any choice. I'll get to that in a moment. If you put these two together, it amounts to an implicit judicial policy of mission contingent deference. I think that mission contingent deference explains the great formative cases and many cases that came later. In State Farm, NHTSA had decided what was the biggest, most important highway safety issue that had come up in the history of that agency without saying a word. It had not a word of explanation. The Reagan administration inherited a rule from the Carter administration that said that you could comply with a passive restraint mandate either with seatbelts or airbags. And NHTSA said, well, we've concluded that almost all of the manufacturers are going to use passive seatbelts that automatically fasten when you close the door, but for safety reasons, they have to be detachable, and people are going to hate these things, and so they're going to detach them, so there are going to be no safety benefits, so we're rescinding the rule. And the court said, wait a minute, how about the airbags? There's enormous amounts of information in the record that they're very cost beneficial. They're not perfect, but they'll get better. You got to explain what you've done. You seem like you are backing off the mission that Congress gave you. It said too many highway accidents. The engineering of cars is a big part of it. We want NHTSA to be in charge of engineering controls. You didn't even explain it. In Chevron, the EPA had explained itself. Despite the caption of the case, it was not really a battle between polluters and environmentalists. It did not look in the posture of the case that EPA was abnegating its pollution control responsibilities. There was an earnest disagreement between the previous administration that wanted to define source narrowly and the new one that wanted to define them in terms of bubbles so that a refinery or a big manufacturing plant could make differential adjustments. There wasn't there was no cost-benefit data, but there was a good deal in the record that showed that in a given industrial facility there would be different sources, different sub-sources with radically different costs of abatement so that a single requirement could result in much more efficient expenditures. And a thought, I was involved and we were pretty confident about this, that it would actually accelerate the trajectory of pollution reduction. In a case like that, the the Carter administration had one view, the Reagan administration had another view. If the court had said, well, we're going to decide as a matter of law that source includes an entire factory, and that's that, well, what if the Democrats came back in and they said, no, we want to go back to a single smokestack? Or what if the evidence showed that the bubble idea was wrong and there was an evolving interpretation? If they decided that as a matter of law, it's that they would have felt they were making a policy decision, which is still somewhat up in the air. I think that it is a tolerable account also of the 30 years of cases that have come subsequently, including many that look inconsistent or opportunistic if you look at them through a narrower doctrinal lens. Let me concede that I cannot stretch my view enough to explain Massachusetts versus EPA well. It is true that to many of the justices, EPA looked off mission. It was a little bit like airbags. This was the biggest environmental issue of the time, and EPA said, we can't be bothered. You know, we really don't want to get involved in this. On the other hand, EPA had given an elaborate rationale, both in terms of the statutory structure, which we're now learning a lot more about the difficulties of regulating at the national level without international agreements. May have been right or wrong, but it was certainly plausible, and I agree that the courts brushed it aside. But I think that the two that Kathy focuses on, the recent ones of King versus Burwell, Michigan versus EPA, are quite consistent, especially if you realize that the courts are reacting to something, this big, massive enterprise. The posture of the case makes a huge amount of difference. She emphasizes, people have emphasized, that in King versus Burwell, this was a major question exemption to Chevron. Plus, what is the IRS's expertise in setting up health insurance exchanges? It was not the expertise agency. To me, the most important thing about the case is that the chief is emphasizing fidelity to the mission that Congress set up. Congress had passed a statute, it had had some intentions, and the interpretation that King wanted to put on it, in the justice's view, would subvert, maybe even destroy the whole statute. You can't expect an agency to interpret a law, even if it's something of a stretch of an interpretation, in a way that undermines the whole thing. So I think that the fact that the administration had been conscientiously pursuing the statute that Congress passed made a great deal of difference. And I admit that for that reason, he did not have to go all the way to saying this is our decision, not deferring to their decision downtown. Maybe he had some strategies in mind for further chipping away at Chevron, I'm not sure. But imagine in the reverse case where the administration had said, no, the statute says we only give subsidies to state exchanges. We're not going to give them to federal exchanges. And somebody in a state that was being operated by a federal exchange sued and said, I didn't get my subsidy. I think you should interpret the statute differently. I doubt that the court would have said, major question, we're going to take this on. And our view is that their interpretation of not doing this is going to undermine the statute, and so we are going to come up with our own. I think they would have deferred to the agency under those circumstances. Michigan versus EPA, there was a huge fact right in the middle of this case. It's true that EPA was on mission. They were controlling pollution. They were making stricter standards that were going to result in less of a certain kind of pollution, mercury and other toxic emissions. But for a decade, as this thing had been wending its way through the agency, there was no evidence of benefits. Their benefit calculation from controlling mercury was trivially different from zero for the nation as a whole, for a pollution control that was going to cost many, many scores of billions of dollars. Now, it's true that they came in and said, oh, but wait a minute, It's going to do some other things on particulate matter, other kinds of pollution are going to go down. It really felt like the dissenters it felt like a make-weight in all of the academic debates, in all of the rulemaking record. If you want to control particulate matter, control particulate matter. You have all sorts of authorities for doing that, and presumably you can do it cheaper than just saying, well, we're going to have some mercury-specific controls, and then we're going to look at what it does for particulate matter as well. So it looked, I think, to certainly a sufficient number of justices, that it was on mission, but it was not being conscientious. Here it had a rule that was going to cost a fabulous amount of money. The best evidence was that the rule itself was going to produce trivially small benefits, and it said, we don't care. We don't even have to care. So I think that they were putting them back on track. I want to say may I say two final things, or am I done?
Quickly.
The courts emphasize, and Kathy emphasizes in her paper, that the judges are deferring to expertise. I think that they're wrong, and I would encourage Kathy not to follow them on this. There's actually not a lot of expertise in these cases. In the cases that you look at, whether doctors should be permitted to prescribe pharmaceutical drugs for assisted suicide, okay? Transgender bathroom rules. The question of a source in Chevron. I was involved in that. I'm not in the petroleum business. There was not a lot of expertise in very few of these cases. FDA, some financial regulation, there is some. It's a question of policy judgments. It's a question of one of the political branches under deferred delegated authority making decisions of policy that involve large amounts of questions of value and questions of politics. And it doesn't make any difference whether it's an IRS rule or an HHS rule or the Justice Department or the Department of Health. They're all talking to each other. These were policy judgments. The IRS didn't have to call up HHS and just explain how these exchanges work. These guys were all on the Obama team. This was called Obamacare. They were trying to make it work. The statute had gambled that the states would all fall in line. They weren't. They were extemporizing. It was a policy judgment, and I think that we should look at the deployment of the next stages of mission contingent deference, and I think moving a little bit away from Chevron in those terms. I think it is a stable, it's a stable doctrine and will continue. And many of the boldest decisions of the Obama administration really involve matters of explanation. I don't think that it was a matter of expertise in Michigan versus EPA. They simply hadn't explained themselves. There was this huge amount of data that made what they were doing look goofy. And they said, we don't have to tell you about it. And in the case, and I think I'll close with this, Texas versus United States, the district and circuit court decisions have a lot resting on interpretation of the immigration laws, but they also point out that this enormous change in national policy was made without any notice and comment at all. No explanation, no nothing, just a declaration. Under my view, it's violating one of the two important parts of the doctrine of mission contingent deference. That is, the agency's got to explain itself. That's the most vulnerable part of that decision. Thank you.
All right, thanks, Chris. I'm now going to let Dan close it out.
It's great to be here. I've found all of the presentations really enlightening. I've also decided not to try to joke because people have been having mixed luck with that, and I'm not sure.
They've been getting worse over time.
Anyway, so I thought I'd start with a little plug for my paper because it's not really what I'm going to be talking about. The paper, which is written with my colleague Ann Joseph O'Connell, is called Agencies as Adversaries, and it's a more general examination of conflict between administrative agencies and within agencies. It does have a discussion of how Chevron ought to apply, where we take a little bit of a different approach than Catherine does, and also of State Farm and what might happen in that situation, where you have multiple agencies who might have different views on sort of factual issues or scientific issues. But instead, I thought I would try to talk a little more directly about the subject of the panel, which is Chevron's retreat, which isn't really what the paper's about. What I'd like to say is that I think if there's a retreat from Chevron, it's in the wrong direction or from the wrong aspect of the Chevron opinion. I thought it was very helpful when Ron disaggregated Chevron. But I'd like to add maybe a fourth, although it's closely related, which is the sort of general spirit of the opinion rather than these specific Chevron rules that one might tease out. And the spirit is one that I think is maybe unusually candid about certain aspects of statutory construction or interpretation, and also displays some humility about what judges ought to be doing in this area. And it seems to me that it's those attitudes that the court has stepped away from in later opinions, and I worry about that a lot more than I worry about the steps 0, 1, 2, 3, or maybe 4. Because I'm afraid that the court is sort of reverting to a more unself-conscious willingness to interpose its own policy determinations on statutory implementation. I'm not saying that it's necessarily wrong for them to do that, but they seem to be quite unaware that this is even potentially problematic, or in fact, even that they're doing it in some cases. So what I think that the Chevron opinion strikingly did was to first point out that Congress often fails to clearly mark the limits of how far a policy should be pushed, or of what to do when the statute has several different policies and they come into conflict, how to weight them against each other, and that these are primarily policy judgments, not legal judgments. And finally, that judges are not necessarily the ideal people to be making these judgments for reasons both of accountability and of the relationship that exists between Congress and agencies as opposed to the courts. Just as an aside, I would say that I always found that the implied delegation argument in Chevron, or at least interpretation of Chevron, to be flimsy. But recent empirical research by Abby Gluck and others has convinced me that maybe, in fact, Congress does generally intend the agency to be the one with the primary responsibility for working these things out. So I'm not quite as skeptical as I used to be. So I want to talk about some of the same cases that other people have mentioned today. The first one is Michigan versus EPA. And let me just, for those of you who are not as deeply in the weeds on this stuff, say a couple of words about the setting of the case. I'm not sure I quite interpret it the same way that Chris DeMuth does, but briefly, the statutory setting was as follows. Section 112 of the Clean Air Act involves emissions of toxic chemicals. And for most, I'm really oversimplifying here, but for basically all significant industrial sectors except one, the statute requires that existing plants be brought up to the level of control of the top 12% in the industry. So it's sort of a best practices requirement. Now, there's lots of other stuff, and it's a complicated statute, but that's the core of what's required for all other industries. When Congress imposed this requirement, it made a special provision for one sector, which was basically electric power plants, and said that before EPA can regulate there, they have to make a finding that regulation is appropriate and necessary after doing some reports to Congress and taking one of those reports into account when it made the determination. It also made it clear that this was separate from the determination of what controls to apply, because the statute provides that this initial triggering requirement is not separately judicially reviewable. You have to wait till the whole thing's over, which suggests that they understood that there might be some gap in time between the two. Now, the question in Michigan versus EPA was whether the phrase appropriate and necessary required consideration of cost and, at least according to the majority, some kind of consideration of the relationship between costs and benefits. And the court said yes, in an opinion by Justice Scalia, 5-4. The dissenters clearly thought that consideration of costs was only reasonable, was required, and I think there are hints that at least some consideration of benefits might also be in play, but I think it's less clear in the dissent than in the majority. Now, the agreement, the point of consensus was under this Chevron Step 2 / State Farm-ish approach that Catherine talked about. The court said it was just unreasonable to decide whether it was appropriate and necessary without considering cost. Justice Scalia is nearly flabbergasted at the idea that anyone might think it was appropriate to regulate without considering costs. Anyone would think that that was rational or appropriate. Now, the problem with that view, I think, it may be that that view is right as a sort of statement of where American society, or at least certain policy-making elites are today. But the problem is Congress clearly didn't think that when they passed this law, because for every other industry, they required imposition of this best practice requirement with no consideration of how much it would cost the rest of the industry or of what the benefits would be in relationship. Congress apparently had a different idea about what was reasonable than the court did. Now, I tend to, I'm not a textualist or even an intentionalist about statutes. I don't necessarily think it's out of line for a court to take contemporary values into account, but I think they ought to be aware when they're doing it and not just assume that what's reasonable is a matter of self-evident truth. We know in tort law, which Catherine is an expert in and I also teach, that determinations of reasonableness are very much tied up with consideration of facts and with a sort of sense of the community of justice. That's why we have those determinations made by juries in tort cases. And I would have liked to see the court itself be a little more aware that it wasn't just stating an objective truth about what was reasonable, that it was making a potentially contestable judgment, and in fact one that even today many people would contest. I think there are many people on the environmental side of things that just don't agree with that view about when you should control toxic pollution. And the court may be doing the right thing in imposing this view of reasonableness, but I'd like them to be aware of what they're doing and to have some better explanation of why they think that's appropriate, maybe in terms of contemporary values. Justice Kagan made a little bit of an effort in that direction by relying on the longstanding practice of the executive branch in terms of cost-benefit analysis, but the majority doesn't even do that. Now, this brings me to the major questions exception, which the court has sort of flirted with in a number of cases, but seems to embrace more wholeheartedly in King versus Burwell. And again, it seems to me that there is a complete unconsciousness that anyone might question the court's prerogative to make policy decisions, or that the court ought to be the least bit concerned about making those decisions in a way that would require it to be especially careful and to exercise particular humility. The rationale of the major exceptions doctrine is that Congress is less likely to want to delegate really big issues of policy to administrative agencies, from which the conclusion is drawn without any further debate that, well, of course, if it's a really big issue, they wanted the judges to decide, right? Well, every argument you can make against the IRS making the decision, lack of expertise, et cetera, applies even more strongly to the Chief Justice, who has far less expertise in healthcare. The IRS actually does quite a bit in healthcare under other provisions, has far less expertise in healthcare than the IRS, and is far more removed from democratic accountability. Again, maybe this still should be something the court should decide, but I think the court should be just a little less self-confident about the innate rightness of having major policy decisions decided by itself. I'd like them, when they do step into these areas, to have a little bit of the awareness that I think you see in the Chevron opinion of the difficult nature of the terrain, the treacherous possibilities of slipping into imposing one's own personal political perspective under the guise of one's role as a judge. So a little bit more humility and a little bit less of this sort of supreme judicial confidence. Thus, I'd like to see judges once again being a little more candid about when they're making policy judgments or value judgments, a little more open in explaining why they think that's appropriate in a particular case, a little more aware of the fact that they're not, after all, democratically accountable. They don't, in general, have the knowledge about the operation of the statute that the agency has, which often is caught up in these sort of policy debates. I think many people think, for example, that a number of the justices in the predecessor Obamacare case failed to understand some basic facts about the operation of health insurance and the economics of health care. And at least there's no particular reason to think that they are likely to understand these matters as well as the executive branch. So I'd just like courts to step back a minute and say, we're doing something here that could be potentially problematic. Let's really think this through and explain why that's appropriate. I think that's especially important in today's political climate. Not exactly earth-shaking news that we are in a highly polarized political situation where people have very sharply conflicting views. The question of what is reasonable may look very differently to a Donald Trump supporter than to a Bernie Sanders supporter or a Hillary Clinton supporter. We need to be really careful in making these determinations that we're not just picking sides in a political fight, that the judges, are not just picking sides in a political fight, that they are trying to ground their decisions in something larger than their own ideological affiliation. Realizing that that will never be possible entirely, but at least to make some effort to distance oneself from one's own political views. And what I fear is that the court, like perhaps the rest of our society, is slipping away from that ability to look beyond the urgent calls of ideology and to take a broader perspective. Thank you.
Thank you, Dan. All right, so we will open it up now for questions. We have quite a few. Let's go over here first.
On Chevron step no, which I think is a funnier name for it, but it sounds like there's a question of whether this is complicated. I thought the chief made it pretty clear that he was kind of joking around when he said this isn't a case for the IRS. I didn't think anybody thought it was a case for the IRS. It was going to be the president's call. So, I mean, isn't that a pretty simple test? If it's important enough that it's the president's call and not some agency that Congress can control through its oversight of the agency, then that's something that needs to be decided by the court and not the President of the United States. Isn't that easy to figure out?
Who wants to try?
Well, I'll say just a couple things, and that is, I think a lot of times the courts look at things differently if there is a direct delegation of authority to the president than they do if there is a delegation to an agency. But also sometimes the courts use doctrines that sound the same in different ways. So in King, you have a different situation, for instance, than you do in Brown against Williamson. Brown against Williamson, you have the question whether the law covers something that could be within the text, but nobody ever thought was within the text. And when Justice Scalia says something like, you don't look for Congress to hide elephants in mouse holes, if it's going to do something that big, you expect it to do it directly. In King, when things get set aside by the chief, at least, in saying that Chevron doesn't apply because it's too big a question here, what you really are dealing with is a straightforward question of statutory interpretation. And I think I disagree with Dan some in the degree to which this turns on agency expertise or questions of agency expertise. The question really isn't a question of the exercise of policy discretion here. It's straightforward statutory interpretation of the sort that courts normally do. And I think that it would have been more to my way of thinking, more straightforward if what the chief said is not that Chevron doesn't apply because the question is too big or because the IRS isn't the right agency to decide it, but because it is a straightforward question of statutory interpretation, and that is within the realm of the courts. And if the courts think that the statute says something that the backers of the law would want to be different, it's up to them to go back and amend. I think everybody realized that in the political environment we were in, the amendment was unlikely to happen, but that normally is not something that moves the court in statutory construction.
I agree with much of what Ron just said. I do think it was a matter of statutory interpretation, and I think the court could perfectly well have dealt with that under Chevron Step 1. That's what Chevron Step 1 is supposed to be about. So I'm not necessarily objecting to their deciding that this was a statutory interpretation, but rather their assumption about important issues being necessarily suited for courts just because they're important. I also think that Roberts was joking, but maybe in a different way. Obviously, I would think, I don't have any inside knowledge, but it would be hard for me to imagine that the IRS made this determination in a sealed room somewhere with no input from the White House on something that obviously was of critical importance to the White House. Clearly, this was a presidential decision in the end. And in saying that he wasn't going to defer to the decision because it was made by the IRS, it seems to me that wasn't, in fact, a very serious argument, that no one in this particular case could believe that the IRS would have made this decision entirely on its own. The IRS is, after all, part of the Treasury Department, and the Secretary of Treasury does, in fact, serve at the pleasure of the president. So it's hard. It's not as if it were made by the Federal Reserve Bank or somebody else who might have operated independently. So I think that was kind of a make-weight argument there.
Here's what I think. I don't think there was a joke there. So I think it's important. This is a decision, right, that was joined by Justices Kennedy, Ginsburg, Breyer, Sotomayor, and Kagan, many of whom have pretty strong views about Chevron deference and are not among the quote-unquote Chevron skeptics that everyone's usually talking about. So there was a lot at stake in that case. I'm not saying that Chevron was front and center, but I think there would have been a lot of scrutiny of what was said as to why Chevron is pitched aside. And I think, I guess I agree with Dan in the following respect, that Brown and Williamson is different because this extraordinary question comes in as a factor within why we're going to resolve this case at Chevron step 1. And one could easily have placed that kind of frame on this case, and it wasn't. And you have other justices signing on to that proposition. I think there was an attempt to make this a very extraordinary case. That's why I mentioned in my opening remarks that it's both, this is a major question, and I agree also with Dan, although it's interesting, I have a question for Dan, because the thrust of my view is that this Chevron step 0 presents the kind of problem Dan was talking about. There's a section of my paper that's called Judges as Policymakers for Major Questions, and I don't think Michigan versus EPA represents the same kind of threat. But to just cabin that for a minute, get back to your question, I think there's something purposeful going on by saying this isn't a case for the IRS, because there's some justices signing on to that majority opinion that care quite a lot about the expertise of agencies deciding questions, et cetera, et cetera.
So you might be right. My impulse, at least in looking at that case, would be to say that those justices would probably have been willing to sign on to any kind of opinion the Chief Justice wanted to write that came out that way.
Maybe, but we should also just be, so that could be true, and that's my, I guess my interest in this case is looking at, as I said at the outset, as a kind of conceptual model. I do think this kind of underlying question that's punted away entirely, and the only judge to have talked about it all was Judge Edwards in dissent in the Helbig case, but there he didn't worry too much about the idea that it was joint authorization to 2 agencies, and there's a line of DC Circuit doctrine saying when multiple agencies are involved, they won't get deference. I think that the idea of the justices signing on to a proposition that swept that issue under the rug was important here too. In City of Arlington, in dissent, the Chief Justice pretty clearly seems to be saying that this norm of giving authorization to multiple agencies is a reason to put all of those kinds of issues into step 0. That would be a nice way to buttress that line of DC Circuit doctrine that wouldn't give any deference at all. And I don't think, so there are costs, so maybe, I guess I would only differ in that I think the justices signing on understood what the costs were. I don't think if the costs, I never think if the costs get too high, you jump off the train. So I think there was some attention to it, and clearly I think many of those justices probably think there will be ways to distinguish that case down the road, and this expertise issue gives them one additional way. So that's why I think, maybe it's a joke to the chief, but I think others might have cared a lot about that aspect to it.
Okay, let's see if we have another question back here. I think we can only take one more. I'm getting the signal from the front.
So I wanted to talk for a moment about your view on whether judges deciding the case themselves on the interpretation or leaving that discretion is really, leaving that to the administrative agency really changes that much from the judge's discretion in the case. A judge that thinks the agency's wrong is going to say that it's unreasonable, perhaps, or that it's, if they like what the agency's doing in their interpretation, they may say, oh, that's a perfectly reasonable interpretation. So I'm not sure that, first, that it's that much additional discretion to move from the judge interpreting it themselves to saying this kind of really hard look of what the agency's doing. Both of them give great discretion to the judge to make these calls. Instead, I would say it's a change in the flexibility of when things change in the future from the executive branch to the legislative branch. If you're doing more of deference to the executive branch, if the executive branch changes, well, then that's a new interpretation. But instead, if a judge decides that it fixes the interpretation, it can only be changed by Congress. And the question then is, should Congress be making these calls to the executive branch going forward?
Yeah, I'll try to be sure. I think that That is right. I think the following. I think, one, a focus on thinking about how agencies respond to doctrine is important. And so I actually think, so what's new or different about a kind of conceptual model that is a step 2 of Chevron with a buttressed State Farm, is I think agencies might respond to that in actually somewhat productive ways when it comes to cost-benefit analysis, et cetera. And so I think that's an important piece of this. But you're absolutely right to point out one of the factors, I didn't mention this that I'm looking at in this body of DC Circuit cases that I think is very significant is not only looking at when the agency wins or loses and whether that happens at Chevron step 1, 1, 2, or 2 with State Farm, but also has the agency changed its position, is what's going on, and this would, I guess, feed into Chris's theory about mission contingent deference. Sometimes the idea seems to be that the agency's changed its position and not only hasn't given enough of a reasoned decision making, but the court just seems very, very skeptical that it's anything other than just a kind of ideological switch. So I think the court could be framing a role there for itself.
Yeah, I just want to add very briefly that, because I think it's raised by the question, I don't think we really know how much effect the Chevron doctrine really has. There have been some empirical studies, they're kind of mixed. Some of them conclude that after sort of at least an additional adjustment period that Chevron didn't really make any difference in terms of how often agencies win and lose. It certainly raises wonderful conceptual issues, but whether administrative agencies will be more hemmed in if the court gets rid of Chevron is just something we don't know one way or the other.
All right, with that, please join me in thanking all of the panelists.